Well, good morning, colleagues. Formally opening the 12th meeting of the Referendum-Bill Committee. We have had apologies from Patrick Harvey, but there will be no substitute from the Green Party for Patrick. We've also had apologies for Annabel Goley, and John Lamont is here from the Conservative Party. I don't think there are any other apologies. This is the first of 5 meetings which we're going to be having, which the Committee will be having and taking evidence in regard to the main referendum bill for stage 1. And very much a warm welcome to our first panel of witnesses from the Law Society of Scotland, from the Faculty of Advocates, Michael Clancy, from the Law Society, and Richard Keane and James Wolfe from the Faculty of Advocates. Good morning to you. I understand none of you wish to make any particular opening statements, and we're happy to move straight to questions. Is that correct? Well, thank you. I think, James, I can come to you first, if that's okay.
Okay, thanks a lot, Convener, and good morning, and thank you for coming along and sharing your time with us, and thank you for your written evidence. I don't know if you have had an opportunity to look at some of the evidence submissions in relation to the second panel. We've had a submission from the No to AV campaign, and in that they raised some concerns about the technical conduct of the referendum. And I just wanted to, as they do relate to some legal points, I just wanted to put those to you and see whether you had a view on them, or whether you even wanted to reflect and come back to the committee on them. The first of these relates to the deadline for appointing referendum agents, which is in section 16 of the bill. And their contention is that this is too early and it is a deviation from the normal date under the PEPRA rules that applies under UK law. So they're flagging up that there's a different approach being adopted here, and I wonder if you see any issues with that.
Thank you very much indeed, Mr. Kelly. We haven't looked at that provision in great detail. In fact, I think we didn't comment on it when we made our submission to the committee, and so therefore I think it would be beyond my remit to commit the Constitutional Law Subcommittee of the Society to a view on that at this moment, but I'm quite happy to take it back and ask them if they have any views on that.
Okay, I don't know then, Convener, if maybe the practical way forward is to draw the Law Society's attention to the comments of the No to AV campaign and ask them to, reflect on those, and if they think there are any relevant comments for the committee, to feed those back.
I think that's appropriate. Okay. John, do you want to...
yes, thank you, Convener. My question relates to the fact that in the Referendum Franchise Bill, there's a date when the Act will be repealed, but there is no such provision in the Independence Referendum Bill for the Act to be repealed at some point. And I know it's not your bill or your drafting, but I wondered if you think that there should be a date when the Act is repealed after the referendum has taken place.
Perhaps just to clarify a point arising from the introduction, I represent the Faculty of Advocates, not the Law Society of Scotland. It's quite all right.
Apologies.
And I didn't want to open up an internecine turf war with the Law Society, even though they make a claim to be the leaders of the legal profession in Scotland. We can put that to one side as well. I know it's terrible. And just to be clear, the faculty as a body does not take a view on the constitutional question, just as this committee is looking at the bill in the context of its operation. So the faculty is here for that purpose as well. In response to the question, it seems to me that there is a political dimension to your question, or potentially a political dimension to your question. And I wonder if that, therefore, is a matter that should be determined by this committee.
There wasn't any particular political dimension to what was that. I mean, I simply thought from a tidying up perspective, keeping the statute book clean, it might be wise if the Franchise Bill, the Franchise Act, once it's enacted, is actually removed and repealed, whether the same should not also apply for the Referendum Bill, and are you aware of any reasons why that should not be the case, or would you think it would be preferable from a legal perspective for it to be repealed?
I can see no reason why it would require to be repealed, given that it determines a referendum on a specific date in September 2014. Once that date is passed, the Act is essentially functus anyway.
Thanks, Convener. I think also that the terms of the Section 30 order require the referendum to be concluded by the 31st of December 2014, so there is an extent to the competence anyway. And if, Ms Lamont, you're looking for a clean statute book, there might be other measures you want to start with than this particular one.
I agree.
Adria?
Yeah,
Tavish?
Convener, I wonder if I could start, Mr Clancy, with the Law Society's submission in respect of Section 13. And in the final sentence of your observations around Section 13 on campaign rules and general offences, you say, and I quote, "These offences appear to be strict offences and there is no provision for a reasonable excuse defence." Would you be so good as to explain that thinking?
Well, our Criminal Law Committee took a look at this, and there is a provision in Section 13 for various offences, but there doesn't appear to be any statutory defence, and we thought that it might be appropriate for there to be a statutory defence of having a reasonable excuse. And you see that in terms of Section 13(1), a person commits an offence if the person alters, suppresses, conceals or destroys any document to which this subsection applies. And then if you see at Section 13(4), the office holder commits an offence if, without reasonable excuse, the office holder fails to supply the relevant person with that information. So there's, within the terms of this particular section, there is a distinction between these two types of offence. Now, a reasonable excuse for altering, suppressing, concealing or destroying a document might be that it was destroyed inadvertently and not deliberately. You don't think so? Okay. The faculty disagree. Another internecine war is just about to erupt.
Not at all. We don't consider that these are strict offences as suggested by the Law Society. If we can look first of all at Section 13, subsection 1, the offence only occurs if one takes into account 13(1)(b), because there's an "and" at the end of 13(1)(a), subparagraph 2. So a person has to act with an intention of falsifying a document. There has to be intent. If one looks at Section 13, subsection 4, then, as has been noted under reference to paragraph A, a person has to act without reasonable excuse. Under subparagraph B, the office holder has to knowingly supply. So there has to be knowledge. Under subsection 5, a person commits an offence if with intent to deceive. It's not an offence of strict liability. There has to be intention. If one then goes to the further offences that are set out in Schedule 4, paragraph 10, this is at page 91 of the bill as I have it, we see that there, so far as offences arising under subparagraphs 7 and 8 are concerned, there's provision for a defence that the offence arose from circumstances beyond a person's control and that they've taken all reasonable steps. And then if we go to Schedule 7, which sets out the further offences which are cross-referenced in Section 13 of the bill, we see, this is at page 135, at paragraph 5(1), there is only an offence if a person acts without reasonable cause. Now, if you bring all those provisions together, it appears to us that these are not offences of strict liability at all. At every turn, there is a provision about reasonable cause, knowing or intent. And therefore, we don't consider that there's the additional requirement for a statutory defence to be introduced into the bill.
respond to that? Are you?
Well, I take the Dean's point, and of course the Dean has highlighted something which we had identified at the start of our memorandum, which is this is quite a complex bill. But even in terms of section 13(1) small b, if the intention element on page 7 of the bill, the person does so with the intention of falsifying the document or enabling the person to evade any of the provisions of Schedules 4 to 6. I think there's a distinction between falsifying the document and suppressing, concealing or destroying. But these, I think, are points of detail which I'm perfectly happy to concede the Dean's point that there are other provisions which allow for defences. I was thinking particularly in terms of destruction.
Kind of line of argument since that one got nowhere. What I'm actually also interested in here is who these offences apply to. Is your understanding, certainly my reading of the bill, is these offences, potential offences, apply to campaigners on both sides of the campaign that will be initiated by the control period starting on the 30th of May in 2014. Would that be your understanding of who these potential offences in this potential legislation will apply to?
First of all, there are distinctions between offences which can be committed by office holders and offences which can be committed by other persons, but they will only be committing an offence in what one might term qualified circumstances. So if they bring themselves within that, then they will commit an offence. But it's not limited to office holders. I agree with that.
And thank you. And therefore, in some other evidence that we've had for this morning, it's noted that there is a series of detailed rules and provisions in respect of investigations by the Electoral Commission punished by the very points you've just been making in relation to potential laws, potentially punished by that are due or could be applied, or will be applied, I suppose, in breach to members of campaign organisations or people related to those campaign organisations. But as this other evidence says, it doesn't apply to ministers of the Crown or Scottish ministers in any sense whatsoever. Are you familiar with that, in the sense that it appears to be one rule for all those involved with campaigns, and yet there is no potential equivalent provisions that apply to ministers who may be using public money in campaigning sense as well?
I'm not sure if I entirely follow the point, because if a minister acts in a way prohibited by Section 13, an offence will be committed. There's no exception because of his status as a minister. He falls, if he qualifies within the terms of Section 13, an offence will be committed.
I agree with that.
Yeah, that's helpful. Thank you. Can I ask one other question, Convener, and that relates to, on a different area, but that relates to the Section 30 in relation, it's more general about Section 30 in relation to the range of information and provisions in the bill which are very broad. Section 30 of the bill basically allows ministers to rewrite the provisions of this bill. There's no final deadline. There's no limitation on that power or indeed circumstance. Have you given any thought, either the faculty or the Law Society, given any thought to the breadth of that provision, Section 30? That's the Section 30 provision.
I shall immediately concede that we have not, but we would be happy to look at it and to make any written submissions thereon.
We did make comment on Section 30, Convener, and in that we were suggesting that there is no obligation to consult on any subordinate legislation which Scottish ministers might bring forward under this provision, and we think that that would be a useful method of fleshing out any objections or questions which people who might be subject to this provision to bring forward, and so therefore there is, I think, a need to insert something along those lines into the bill. But in terms of the Henry VIII, or is it James VI kind of provision here, you know, this is something which we see in statutes very regularly, and whilst one might have jurisprudential objections to the employment of executive power like that, again, we've got a lot of precedent for it.
Thank you. Thanks very much.
I think, Stuart, you're supplementary on this.
Well, Convener, if that's all right. I just wanted to pursue it a little bit. I mean, I'm glad you said this is not unusual, whatever your view of this particular power to make supplementary, etc., provisions and modifications, it's become routine, if I can use that phrase to describe it. But would you concede that at section 34, it's clear that under this particular power, it would be the affirmative procedure that's used, and therefore there is a parliamentary process that would take place in terms of any changes if this particular part was used?
Yes. There is a parliamentary process.
Yeah, so there's a parliamentary process. And secondly, are you aware of precedent in terms of consultation on such a power in other bills?
I think, although I'm not entirely sure, that in the High Hedges Act 2013 there's a provision for consultation by ministers. And,
but you seem to be struggling slightly to find...
No, I'm not
precedent.
struggling. I'm just being diffident. There is a provision in the High Hedges which was accepted by the Minister because that is something that the Scottish Government has undertaken to do in any event, I think is the quote from the official report.
Yes, but I'm not aware that there's a general provision that consultation takes place on secondary legislation in general terms, but in particular in relation to this particular power.
We respond to many consultations on subordinate legislation throughout the year, yes. so it is an ordinary course of event. Whether or not it's formally stated in an Act of Parliament is another matter.
It's a different matter, yes, okay, thank you.
Did you comment on that, Richard, or James? Or?
Only that obviously there would have to be a positive vote of the Parliament on the issue, but nevertheless there may be some substance in the suggestion for consultation. We have not taken a view on that, but we're happy to look at other precedents.
Linda, I think you had a question.
Yeah, a couple of sort of general questions, mainly for the Law Society, I have to say, Michael. First of all, the role of the Electoral Commission. It's detailed in a lot of the points that you've put forward. And I just would be interested in your view of the integrity of the Electoral Commission.
I have no view which I can advance on behalf of the Society. It's not something we've specifically considered, but on every occasion where I've personally encountered the Electoral Commission, they have acted with utmost integrity. Thank
you very much. And the other thing, is just a small thing, it's Part 4 publications. You note that it's about the Edinburgh Agreement, paragraph 29, stating that the UK government has committed to act according to the same rules during the 28-day period. And you're posing the question, does this mean that the UK government will follow Purdah in the same way as the legislation sets out? Would that be a veiled suggestion that we should check up on this and perhaps as a committee try and get this in writing from the UK government, in that the Section 30 agreement, as we know, is very much a mutual respect and gentleman's agreement, if you like.
But the Edinburgh Agreement does contain this provision, and it's mentioned in the policy memorandum, and so therefore I think that one can take that as being if it's under the signature of the Prime Minister with the First Minister in attendance and signing too, that people understand what's what. But I think there is a distinction between a statutory provision and something in an extra statutory agreement, which people may want to flesh out.
Thank you very much.
Thank you, Convener. Good morning. Again, in the same section, Schedule 3, Rule 40, under the heading of Orders for Production of Documents, I wondered if you would like to, Mr Glancy, flesh out a little bit your concern about the question you pose at the end about the rationale for allocating this jurisdiction to the Sheriff Principal.
I think it was simply that there was a difference between this and the 2011 Act, and we were just asking the government the question, why should there be this difference? I'm sure they have a perfectly good answer for that.
Hopefully, yes. But I did notice in your evidence there were a number of similar issues. One around the use of the rooms or offices of public authorities, some about who had access to polling stations, etc. There seemed to me to be quite a few of those details, perhaps, that seem to be at odds with precedent in the past. And I wonder whether you think this is just, how can I put it, just perhaps hasty drafting, or whether you would be concerned that this is being done for some other reason. I can't personally see any reason why that would be other than hasty or not very good drafting, but I just wondered if you had a view.
No, I think with all due respect to the draftsman, this is quite a well-drafted bill. We had very little difficulties with the actual drafting, as you see from this. But these questions about, for example, the use of rooms by Scottish public authorities, or which are in the possession of Scottish public authorities, I think come out of the fact that the Political Parties, Elections and Referendums Act, which contains some of these provisions, only applies to referendums run by the United Kingdom government, whereas this bill refers to a referendum run by the Scottish government, and so therefore it is being tailored to Scottish conditions. But when I highlighted that Scottish public authorities, there are so many of these, and I doubt very much whether the Mental Welfare Commission for Scotland would really like to have a ballot box in their vestibule on the 18th of September. But, you know, it's adding in that which gives it a more distinctive flavour, as it were.
I think many of the points you raised are very interesting points that we probably want to raise in other evidence sessions with other witnesses. So thank you very much for that.
Thank you. Annabelle?
Yes, good morning, gentlemen. And I perhaps should say for the record that, like John Lamont, I am currently a member of the Law Society of Scotland. I did make that declaration at the very start, convener, you may remember, of our first meeting. I would like to go back, if I may, to section 21, and looking particularly at the Law Society of Scotland's written evidence this morning, and the Law Society states that section 21 is important because it reflects paragraph 3.1d of the European Commission for Democracy Through Law, and that is the Venice Commission, Code of Practice on Referendum, brackets 2009, close brackets, which requires that authorities, quotes, provide objective information, close quotes, about the referendum. And I just wonder if you foresee at all anything in the bill that would preclude or make more difficult the provision of objective information in terms of the way that the bill is drafted, or do you feel rather that the Electoral Commission, in ways that it has done in past examples, will be able to provide objective information as required about the referendum, the question, and voting in the referendum?
I don't think there is anything in the bill of itself which would make that task more difficult. As you've pointed out, Ms. Ewing, the Electoral Commission has a lot of skill in doing this, and I'm sure that they'll be able to distill the issues which may be packaged in terms of information for voters about the referendum question and voting in the referendum in terms of section 21. I was simply reflecting on the fact that I had been introduced to the European Commission for Democracy Through Law's Code of Practice, and that it contained provisions with which this bill accords. And of course that is important because handing this duty in terms of providing information is something which tries to avoid any incidence of bias in the provision of information about the referendum or the question or voting.
Thank you. I wonder if the Dean of the Faculty would wish to comment.
I think the only additional comment I would make is that it is clearly implicit within Section 21 that the Electoral Commission will act objectively in discharging the function referred to. And I also notice that in terms of Section 21, it must take these steps. It's not a case of it exercising any discretion. So again, that underlines that this is clearly more of a black and white situation than one of judgment.
Thank you, Convener. If I may, could I ask one other technical question? And looking at Section 31, which sets forth the ways in which a legal challenge to the referendum result can be brought in terms of the certification of the votes cast. The Law Society, certainly in its written submission, suggests that the process set forth, which is to be by way of a judicial review, is actually in conformity with past precedent in terms of referendum legislation. I just wonder if perhaps both gentlemen could comment on that, just to get it into the oral record, that you know, that this, in the view certainly of the Law Society, is in conformity with the general kind of practice that one would expect here.
Yes, we would concur with that. The appropriate step to take would be to present a petition to the supervisory jurisdiction of the Court of Session by way of judicial review. The only additional comment I would make is with regard to the period of 6 weeks. It's not entirely clear why 6 weeks has been chosen. The position in England and Wales is that the time limit for applications is taken up to a maximum of 3 months. But maybe less, and indeed the proposal within the Judicial Reform Bill in Scotland is that the period should also be 3 months. So it's not immediately obvious why, for the purposes of this particular bill, a period of half that has been taken. But that's just an observation, not a criticism at all.
Point up for future evidence sessions. Annabelle, anything else?
That's all for the moment. Thank you, Convener.
Anybody else want to? John?
Anti-Convener, I'm actually a member of the Law Society of England and Wales, just to correct the official report, not Scotland.
Can I ask?
It's the value which you get as a member of the institution.
Has anybody else got any other questions before I ask some very general points? A very general point, I'm not sure this fits in your remit or not as you see it in terms of the expertise you bring to the table. In terms of the expenditure figures allowed for both the, for want of a better words, the yes campaign and the no campaign, we've heard there is some evidence coming at us that, you know, disputes what the Electoral Commission's findings have been in regard to the amounts available. The Electoral Commission, for instance, effectively have said for the no parties would get £1,431,000, the yes parties £1,494,000, which seems to be, on the face of it, you know, a reasonable playing field. Have you any views on that? I want to make sure, because I want to make sure.
We would have no views on this at all.
Okay.
And similarly, from the Law Society, we would have
just want to make sure that's not there. In general terms, is there anything else you'd like to draw to our attention you think it would be useful for the committee to hear in terms of either the evidence you've submitted to us, Michael, or the Dean, any other evidence you think we should consider for future evidence sessions so we can properly scrutinise the bill?
We have nothing to add at this time. We have noted that we will look at a number of further provisions, and if we have anything of substance to contribute to the committee, we shall arrange to submit a written response on those points.
Thank you.
From the Law Society's point of view, we've given you a written evidence, Convener, and hope that it will allow some questions to be asked of future witnesses, and when we get to further stages in the bill, then we'll be making representations as we ordinarily do with bills.
Yeah, very grateful, particularly for signalling up the areas we need to consider for future evidence-taking sessions. I'm very grateful also for you coming this morning, and my apologies for putting you into the wrong camp at the beginning. So. Pleasure. We shall now just suspend for probably 10 minutes. Okay. Okay. Right, okay, we start the second session of our evidence into the Scottish Independence Referendum Bill this morning, and welcome, gentlemen, to the proceedings of our committee. Can I give a particular warm welcome to Professor Richard Wynne-Jones, Professor of World Politics and Director of the Welsh Governance Centre at Cardiff University, to William Norton, Responsible Person and Referendum Agent for the No to EV campaign, and Willie Sullivan, the former Director of the Field Operations for the Yes to Fairer Votes. The theme of our second set of witnesses is to try to draw on the experiences from the two previous referendums, the referendum extending devolution in Wales and the referendum on changing the voting system for the UK Parliament elections from the first past the post to alternative vote system, both held in 2011. I understand that all three would like to make a brief opening remarks. I don't know who wants to begin. Richard, do you want to kick this off?
Okay, thank you. I should start with a confession. First of all, I have a cold, so my Ynys accent may be a little bit more impenetrable than usual. And secondly, I'm not an expert on electoral procedures per se. I think my colleagues on either side are much more knowledgeable than I am on that count. I have, however, written a book with a colleague, Roger Scully, on the Welsh referendum, and looking at the politics and voting behaviour. Inevitably, there are procedural elements which feature in that. We'll start by saying that in many, many ways, the referendum in Wales in March 2011 was deeply unsatisfactory. It was a very low turnout event. The campaign teetered on the brink of farce at times. Several reasons for that. The most fundamental was that, in my view, this was not an issue that should ever have been put to the vote in that way. It was a choice between two different types of primary lawmaking powers, which was frankly a rather arcane issue, which was extremely difficult to explain to the public, let alone mobilise around. And so that makes it fundamentally different from what's going to be happening in Scotland in September 2014. Nobody could not claim that that is anything other than a fundamental constitutional issue. There were, however, problems with the framework under which the referendum in Wales were held. First of all, and I summarise, the timetable was incredibly compressed. So one of the key features of the Welsh referendum is that there were no designated lead campaigns. That decision not to designate happened on the 28th of January 2011. The referendum was happening on the 3rd of March. So, you know, just a month out from the referendum, a fundamental decision about the shape of the referendum is made only a month out. We also discovered that the legislation, the preparer, allows for gaming. The no side did not designate, it chose not to ask for official designation, apply for his official designation, knowing that the impact of that would be that the yes side would then not be allowed to be given designation. And in a sense, that was, on their part, a levelling down of the playing field, in a sense. And so there was an element of gaming involved. Thirdly, because of the gaming, the spending limits were absurdly tight. The Yes campaign was not a designated lead campaign. It was a permitted participant. It was only allowed to spend £100,000, which doesn't even pay. It costs you around £200,000 to send one piece of mail to every household in Wales. So the spending limits were absurdly low. And finally, the other thing, even if public subventions had been allowed, and I think this is a point that my colleague to my left will make in a moment, it's not clear that the money would have been particularly useful. It would have been arriving very, very late in the day and would only be usable for a very tightly controlled set of spending requirements. So even if public subventions had been given to the campaigns, it's not clear that they would have been particularly useful. So that would be in terms of the framework. It's also, I think, worth noting the limitations of the media framework. And this may be, in fact, more relevant. There were some Welsh-specific problems with the media framework. But just very briefly, I would say there's a clear tension in terms of the media's need for two clearly defined homogenous sides. They can count the minutes for these two sides. And the fact that in politics it's rarely that simple. And what happened in the No campaign was it kind of fractured in the last few weeks of the referendum. It fractured ideologically between people who wanted to argue that, for abolishing the Assembly and people who wanted to argue for something called real devolution, which was never defined, but was, you know, and there was a kind of an ideological fallout as well as a personal fallout within the No campaign. Now, in the event, the press didn't cover this, but I think there's a real issue in terms of how, in a campaign which requires, in terms of regulation, two clearly defined sides, if there are internal tensions within one or both of those sides. I think the Welsh case raises that issue. And my kind of fundamental point and my final point is that I'm not sure how much of this is directly relevant to the Scottish case, but one of my key concerns is nobody's tried to learn any lessons from this. So it is difficult with referendums anyway. They're one-off events, people disappear instantly. But the Electoral Commission's report on the Welsh referendum was an exercise in self-justification. Pure and simple. They made no real effort to think critically about their own role. And certainly the participants that I interviewed, and I basically interviewed everybody who was a key participant, were pretty critical of the role of the Electoral Commission. And I haven't seen any signs of internal lesson drawing within the BBC in Wales, let alone the BBC in Scotland, for example, taking interest in that case. So my concern is one of, were any lessons learnt from this whole, in many ways, unsatisfactory experience? Literally my final sentence, I feel as if I've been trashing Wales in front of you this morning. The only thing which I would say in a positive way about the referendum, it was the right results, in the sense that the referendum actually reflected what people in Wales thought about the issue on the ballot paper. Not only those who voted, but to the extent that we have any information about their views, those people who didn't vote. And you can't take these things for granted in referendums. So that would be my opening remark.
Thank you, Richard. William, you want to go?
I think you have a note which is prepared by myself and my colleagues, which basically sets out our reaction to the draft bill, to the bill. I'd just like to pick up on a number of points actually that Professor Jones made. Is that firstly, I think partly mainly on the grant, is that whether or not the Welsh No campaign made a tactical decision not to apply for designation, I can't say. I would, from my own experience, suggest that there may have been a financial element involved, simply from our own experience in the AV referendum that was a couple of months later, which was that, yes, there was in theory a grant of, I think perhaps we could have got £380,000, but the terms on which that was claimable meant that no one was ever going to get that amount because it was a reimbursement. You had to spend money on certain items, things like computers, for example, and it wasn't actually useful to the main elements of being a designated campaign, which is sending the mail shot and preparing a TV broadcast. In our own position, we knew that to send a mail shot to everyone in the UK and to prepare a number of television broadcasts would have cost £1 million. Which we didn't have at the time when we would have had to commit to that expenditure. Because with the referendum taking place in the start of May, you have a certain lead-in time you need to prepare 45 million leaflets. So we had to commit to making that expenditure in March at a time before we were designated and when we did not have sufficient donations to cover it. Now, I don't want to be melodramatic, but effectively, I bet my house on being able to raise those monies. I'm quite compassionate that my colleague in Wales may not have been prepared to make that gamble. Now, I think if there had been a slightly differently worded grant, on a lower proportionate amount, it would get over the problem of non-designation. What you want in a referendum is 2 designated campaigns, one for each side, that can give a minimum amount of information on both sides so that your voters can make a fair and informed choice. And I don't think you should be, I think you should make the rules as helpful as possible to achieve that. And that way, let the voters make their own decision.
Yep. Willie?
Thanks. Yeah, I think we all know how important it is to get this right, so I'm grateful and thank you for asking me to come and share some of my learning with it. I've circulated a paper which kind of touches on the learning from the AV referendum, but I wonder if I could just mention 2 or 3 principles that I think we should consider when, and I think you've already began to consider when producing the bill, but to hold in mind when we're thinking about it. And that is that there's no sets of interests with more power or money can influence the outcomes to the benefit of their interests at the expense of most others. And I think this can helpfully be achieved by transparency. So as far as possible, the public have to know what and how the participants are doing and why they're doing it. And I think this needs an element of challenge, not just between the campaigns, but also from the media, obviously, but I think from civil society and as wide as possible. You know, things that are asserted, claims that are made and counterclaims should be open to challenge from out with the campaigns, I think. And to do that properly, I think it needs an application of ethics at various points during the process. And I think we have to acknowledge that referendums and elections are elite-driven undertakings. It's elites that set them up. But there's a kind of paradox here. In order for them to be legitimate, they have to have popular support. And I think we can see at the moment that if representative democracy is not in crisis, at least is in want of legitimacy. And I think these are 2 things I think we can do to address this. One is we can be honest about the fact that it's elite. The referendum's an elite thing, and all you're really seeking is endorsement of the population for an elite settlement. Or we can genuinely try to make it a process in which citizens can take part. Thanks.
Well, can I begin just by asking William Norton a question in regard to the evidence you put to us, William, from the No AV campaign side, in particular bullet point 3 and your high-level concerns in regard to expenditure limits. Could you explain a bit more about what you mean by bullet point 3?
Yes, certainly. The background is that when I was asked to come up here and provide evidence, I had a look at the bill before us. Now, I was aware in the background that there was a discussion that you wanted a referendum that was, I think the phrase was, built in Scotland. And it's actually, what most of this bill does is, of course, it carries over the provision that would have been the case if it had been fought under UK law, under PPERA, the Political Parties Elections Referendums Act. In there is a formula for setting out spending limits for parties, which is different to the one you've got in your bill. So it's simply just from a comparison that of what the 2 provisions would have produced. It does seem to end up with, well, let's think, the position under PPERA would be that you can spend a certain amount related to your share of the vote. In respect of Scotland, there isn't any particular guidance as to what that would mean, but it's obviously a vote at the Scottish parliamentary election. What you've got in your bill is, in effect, there's a sort of, you create a total pot for eligible spending by political parties, and you then divide that pot between the parties in terms of their share of the vote in Scotland. That is a very significant difference from the position that would apply under PPERA. Under PPERA, the presumption is that anyone can involve themselves in a referendum on either side, and they will have a spending limit depending on who they are. If they're just a normal campaign body, it will be the standard spending. If they're a designated organisation, they can spend the most, and if they're a political party, they can spend somewhere in between the 2 depending on their share of the vote. The way the bill approaches it is it appears to seek to cap total spending by the 2 sides, but it doesn't apply the logic of that all the way through and just having a global spending limit for both sides that's equal. So I think that it's a significant departure from PPERA, and personally I'm not convinced by the policy argument for that.
Did you have the opportunity to read the document produced by the Electoral Commission on the 30th of January
yes.
2013, which went into some detail about why they came to that conclusion and recommendation?
I am not convinced with the policy argument having read that document.
Okay. In that case, in regard to what the Edinburgh Agreement said, it said that it pointed to a need for fairness and level playing field in the campaign, and the Better Together campaign in their own submission to the Electoral Commission said the way this referendum is run must be seen not only be fair, but crucially must be seen to be fair. Now, if you take the figures which the Electoral Commission produced, which were then taken by the Scottish Government and put into the bill, the Electoral Commission figures give the no parties £1,341,000, the yes parties £1,494,000. But if we take the example that you've put forward in your own submission, the no parties would have £2,700,000, the yes parties £1,650,000, a 63% advantage. Do you think that provides the level playing field that was being sought in the Edinburgh Agreement or indeed by the other campaign groups?
Well, what you're doing is you're overriding a general assumption that in a free country people are enabled to take part in an election as they choose to. What you're effectively doing is you're imposing an external limit on people depending on which side they wish to support. I think from ease of reference, we can talk about this as either a bottom-up approach, which is what you have in PPERA, or a top-down approach. Now, what you've got in the bill is a half top-down approach that applies just to political parties and the two main campaigns. I find that unconvincing. I'm not convinced by the argument.
The question I asked you wasn't so much about the detail of one side of the argument, the other was, in terms of where the actual Electoral Commission ended up, does that produce a level playing field which is fair?
It produces something which you can call a level playing field, but that you're making certain assumptions. First of all, for example, what happens if a party decides to change sides? Because of the brilliance of the Yes campaign's arguments, suppose a party changes sides. You've then got a deliberately designed unlevel playing field. Another example is what happened in AV, if a major party decides not to register on one side for its own internal reasons.
I recognise it's possible for parties to change side, but I find that concept in terms of where we are difficult to actually realise in reality.
I will give you a further example. In the AV referendum, if you look at the various parties, for example, you had on the no side, you had the Conservatives, and you had, I think, the Democratic Unionists in Northern Ireland. On the yes side, you had, from their official positions, you had the Liberal Democrats, you had the SNP, you had Plaid Cymru, you had UKIP, there was the SDLP and Sinn Féin in Northern Ireland, the Alliance Party in Northern Ireland. There were various Green parties. I'm not being dismissive because I'm not sure whether all of them officially joined the yes side or not. In name, quite a few of them did, yeah. If you'd used the formula approach to all of that to equalise spending, for example, you would have ended up with a global figure for both sides. But in the end, out of all the parties on the yes side, I think only the Liberal Democrats spent more than £10,000, wasn't it? I think that's that sort of a figure. So you're assuming that simply because somebody's included in the limit, they're going to spend it.
Okay. The only party that spent was the Liberal Democrats. But just to say, I think what you have, what the Commission proposed, does provide a level playing field, more than PPERA did.
Richard, would you like to comment on that?
Well, I mean, if one side had a 60% advantage over the other, then I think if that ends up being the losing side, there would be huge questions about the legitimacy of the whole process as a result. I mean, I understand William's points, but forgive me for saying so. I think they're a little scholastic. I think in terms of the particular issue ahead of you in September 2014, it's kind of roughly fair. And I think the PPERA approach would give you something which would not look roughly fair to most people.
William, just for the sake of accuracy, I'm not sure you're aware, but actually the figures that you quote in your spending limits, and you're at 7.5, are actually not the same figures as are in the bill. So you may want to reflect on that in terms of the accuracy of the numbers you've used. There's not a huge difference, but there is a difference.
Maybe a rounding error then. I'm prepared to stand corrected on that. So
it's a wee bit more than that, but just so you're aware of that.
Which figure? Just out of interest, so I can check.
So it's actually for the expenditure for the Labour Party, the Conservatives and Liberal Democrats. your numbers are different to what appears in the bill and in the policy, in the policy memorandum and in the submission from the Electoral Commission.
I'm not going to quibble over numbers.
No, just for the sake of accuracy, so that it's
okay, right.
On bottom up, bottom down, I think, Linda, you wanted to raise something on that.
Yeah,
Willie mentioned that in his evidence.
Yeah, just a quick one, Mr Norton. It's read paragraph 7.8 of your submission, which I have to say, I found the paragraph difficult. I couldn't get my head around the logic. But you said just a moment ago that you thought that the proposal by the Electoral Commission was, I think you said half bottom up, half top down. But you've said here in paragraph 7.8 that it's an absolute top down.
Logic of it. That's why I mean it's halfway through. You have a rule that says the official yes campaign can spend a certain amount and the official no campaign has a certain amount of their limit, and they're equal. So that you might consider as sort of a top-down approach. You're then extending that to include political parties who are assigned notionally to their yes or the no sides. So we're continuing the top-down approach. But then you come to other groups who are completely unlimited as to whether they're on the yes side or the no side. Now, suppose, for example, they were all to join one side on a 2-to-1 by sort of a 2-to-1 break, would that not, on the logic of the Electoral Commission, would that not call that into question? So if you're going to start doing a top-down approach all the way through the political parties, the logic must be that in order to make it to be seen to be fair, to make sure that all of the playing field is level, should you not then continue on and just simply say there is a global limit for the yes side and a global limit for the no side? Now, the practical problems are that there's somebody who's going to, in the middle of the referendum campaign, they're suddenly going to decide, let's say, opticians for yes in Arbroath, suddenly decide that they're very concerned about the need to sort of campaign for a yes vote amongst opticians, and they decide to register with the Electoral Commission, and they're told, well, I'm very sorry, the spending limit has been reached. You can't join that side. Now, that's why I say that a top-down approach is a significant change to the way in which politics is conducted in the United Kingdom, that people who want to campaign can register and campaign. If you have a global top-down limit, somebody somewhere is going to be told you can't join the referendum campaign because we've reached the limit. Practically as well, if you are in the headquarters of the Yes campaign, how do you know what opticians in Arbroath are getting up to? You can't police it.
I don't think we'd want to police it, Mr Norton.
I think you'll find, excuse me, Mr Convener, you'll find that somebody is legally responsible for campaigning limits.
Yeah, I'm sorry, I was being flippant and I shouldn't have been flippant. Please take my apologies for that.
I think it's worth William, if I may call you William, is touching on a real issue. In the Welsh case, the Yes campaign actually stopped raising money in the last few weeks. Which sounds perverse in the run-up to a referendum, but they were worried about, obviously the spending limit was incredibly tight as a result of the non-designation, and so they actually stopped raising money for fear of somebody out there doing something in their name, which they weren't aware of. And so, I've made my general points and my general view clear, but there are some real sticky issues
so
about...
hypothetically, there could be problems. I'd be interested in Willie Sullivan's view on this.
Well, I think it's an improvement. I think under PPERA anyway, if somebody did something that the responsible person didn't know about or couldn't reasonably know about, then it couldn't be included in their expenses. So I'm not sure that is such a big fear. But other organisations, I guess there's a question at which point an interest group registers to be a permitted participant in the referendum. You know, if a professional body recommended to its members a certain position, I don't think they would have to register as a permitted participant. And in fact, what as I said in my paper, the problem with not having a spending limit is you just allow it open to the people that are able to raise the most money, and that tends to favour those who have benefited from the status quo and existing sets of conditions. So I think having an upper limit, and I would agree that there needs to be a public grant allowed to be used for campaigning, because I agreed with everything that was said about that, would be an additional improvement.
The difference between us is, what do we mean by being seen to be fair? Now, if this Parliament takes the view that being seen to be fair means you have a top-down limit on political parties, so in other words, you distinguish political parties from other campaigners, then that's clearly within the competence of the Parliament to take that view. I'm thinking of it from the point of view of someone who's actually having to sort of manage the campaign. So what's fair? I'm looking at it, you compare, how does this bill compare to what would have happened if you'd fought the referendum under PPERA? And however much you argue the pros and the cons, this is an area which is a major change from PPERA. If the Parliament chooses to do that, then clearly the Parliament can do it. I don't have a dog in this fight.
It's interesting that when we take evidence from the Electoral Commission, we need to tease this further out, because they claim in 2.11 of their own document, which they submitted to their consultation document, the end of it, in line with our principles, our advice is based on a bottom-up approach. So I don't want to get into a semantic argument of who's right to be bottom-up and top-down, but there's obviously a difference in opinion about how this has been approached, and we'll have to tease that out later. But let me move on to other areas of questions. I think we'll probably go on as far as we can. That James,
can I just follow up on one point, just for clarification, just to follow your logic, Mr. Norton? If you take paragraph 7.5 of your submission and use the example that you've outlined there, it's what you're saying that, you know, there's a limit for the designated campaigns, there's a limit for the political parties, but the rules around, you know, non-designated organisations are weak. And you use an example there of £150,000 donations. What you're saying is that if say, for example, one organisation produces 20 of those donations, totaling £3 million, and the other organisation, you know, produces 10, totaling £1.5 million. Is your contention that this aspect of the way the bill's drafted allows, you know, an inequality to arise in terms of the campaign expenditure?
I think you're effectively making the point that I was talking about earlier about how far do you take the top-down approach, is that if you cap limits for the 2 official campaigns on a top-down approach, if you then equalise the spending for the parties on a top-down approach, you will still have an imbalance at the bottom in terms of non-party campaigners who can be funded by as much donations as they can raise. Again, it's a question of how far you want to level off the playing field.
I think if I remember correctly, the Scottish Government had a lower figure in that, and the Electoral Commission actually increased it, which is... Anyway, Stuart, I think you had a supplementary, forgive me, to this area.
Yes, thank you. It's actually, I've got a couple of points. Just it follows on from that line of questioning as well. Just in terms of the level playing field element, and there's also the point to what price do you put on democracy? Well, we've heard the issue regarding also the spending limits, and we have to remember as well that, that the current economic situation is challenging, not just in Scotland or the UK, but globally. And if, as you're suggesting, Mr. Norton, that the spending limits are actually increased, could that actually not backfire on both sides of the argument in terms of the electorate thinking, actually, well, wait a minute, there are tough economic times, but here you go again, these politicians just want to spend pound after pound after pound on campaigning, as compared to actually having a fairly level playing field, but actually a level playing field where there are some limits, and the public can actually fully buy into the campaigns from whichever side they actually want to, but also realise that it's been done with a kind of an equitable manner, and also it's not kind of grossly too much in the way of money being spent.
Well, the spending limits for political parties, of course, doesn't come out of public funds, does it? I think I'm right in saying. So if they want to spend a lot of money on themselves, I mean, it'll be a judgment for the parties themselves. And you've got the example of the AV referendum, where, for example, I think the Conservative Party had a spending limit of, I think, £5 million, and they spent actually sort of 600,000. The Liberal Democrats had a spending limit of, I think, about 3 million, but it was that sort of, it wasn't as high. They spent a couple of 100,000, and other parties would have had spending limits of sort of 500,000 or whatever, and they didn't spend it. Now, I think it's a judgment for the parties themselves as to what they want to spend their money on.
But forgive me.
I understand that what you're making is, in a time of austerity, should you be having large spending limits? Well, it's... I'm suspicious that there's a voter somewhere that says, I can trust the referendum result because the Liberal Democrats are limited to spending blob. They say, I can't trust the referendum result because the Liberal Democrats are entitled to spend 2 blob. It's a matter, you're obviously closer to your electorate than I am.
Well, we've already heard it this morning from Willie Sullivan in his earlier comments regarding the issue of politicians and politics regarding the electorate. So it's, and you mentioned there in terms of where the money actually comes from. It's much of the money will actually come from donations and not from the public purse, which is the right thing to do. But many people actually will not distinguish the difference. They'll just see whether it's designated organisations or political parties spending money.
A question, Stuart, or is that just...
Yeah. Well, just I want to get that point on the record. But I've got another question actually. Just it's regarding to Mr. Norton again, he said earlier on. He actually had this in paragraph 7.9 of his paper regarding the parties changing sides, and he also commented on this earlier. Now I'm sure that colleagues around the table from the other side of the campaign will probably kind of dispute this particular point, and I wouldn't imagine Labour, the Conservatives or the Liberal Democrats actually changing sides in the run-up to this, although there are campaign groups within some of the parties who actually do support independence. But do you realistically see that as something that may happen in the Scottish referendum?
I think it's something that's worth considering. If you're devising a theory on the basis that it is going to happen. I think I defer to your experience of politics, but not everything happens that everyone expects will automatically happen.
Oh, but in all fairness, I mean,
I've got an example for AV.
It's the Scottish Conservative and Unionist Party.
No,
I wouldn't imagine they're going to change.
Let William finish his answer.
For example, you had the AV referendum. You had one of the, I'll call them the major parties of British politics, the Labour Party, did not officially take a stance on either side. Now, that would have taken out of an entitlement to spend about, I forget the exact amount, sort of £3 million or whatever, which would have been a significant amount of party spending limits. So that would have significantly upset any formula. If a formula like in the bill here had been applied to the AV referendum. So would that then have produced an unbalanced result that would have led to people thinking that we can't trust the referendum because the spending limits are unbalanced?
Can we move on to Stuart Maxwell now, please?
Sure. Thank you, Convener. I want to raise a point which was raised earlier by Professor Jones and is in Mr. Norton's evidence. Mr. Norton, you mentioned it. It was bullet point 2 in your high-level concerns about the issue of designation. Can you and also in your actual piece you go into it in some detail over a couple of pages. Could you explain to the committee the logic behind your thinking that the way that you believe it should operate is that effectively the both or neither rule that you describe?
The both or neither rule is the ultimate level playing field. You have a designated organisation on both sides, or you have no designated organisation on either side. I agree, it is far better if you have a designated organisation for the point of view of getting the message out to your voters. But you can't have a designation on one side only, because by definition you've got an unlevel playing field by design. Now, we had a massive failure in the Welsh referendum where one side did not put in an application for designation, and it led to a very unsatisfactory referendum result. My view is that I suspect that that was mainly driven by the fact that they could not afford to discharge the duties of designation. Now, what you're doing is you're having an AV referendum or a Scottish independence referendum, or you're having a referendum about whether to change whether you drive on the left-hand side or the right-hand side of the road. You need two people able to put a case on both sides and then let the voters make up their own minds. And I think that it's getting a bit Venezuelan if you've got one person that can send out leaflets and have television broadcasts and another side that can't.
I think, Professor Jones, I would like to hear your opinion on this.
The problem is that what we discovered through the Pepera experience in Wales was that you have gaming. It was a clear case of gaming the system, and finance was part of it. There's no doubt about that. The No campaign was simply unable to raise funding. It was unable to raise funding because it had no activist support. And one of the things they were aware of was that if you essentially destroyed the ground campaign and then just kept it as a media campaign, then in particular, given the importance of public broadcasting in the Welsh context, it would ensure that they were getting 50-50 coverage. And so they gamed the system. And so I think a lot of, William and I clearly disagree on some of that, but some of the points he's been making earlier about gaming, or the potential for gaming, I think are really important points, actually, because people will game systems. And it's important, and Pepera was clearly just not fit for purpose in that context. And I think some of the issues which have been raised about all these other kind of the £150,000 here and there, these are about issues around gaming, essentially. So I think that's what we've learned from the Welsh experience. Pepera was not fit for purpose.
Thank you. And on that point, before I come to Willie, can I just be clear in terms of your answer to Stuart, that in terms of the legislation that's before us at the moment, do you think we've got the right approach? Or not?
I think yes, because I think it's just simply unacceptable that one side can just take the other out of the game in the way that they did in the Welsh context. However, I think with an important addendum, I think the points that William are making about incentivising, I mean, William makes the point about, in his evidence, about incentivising designation by actually saying you can spend some money on the actual campaigning. And I would say, I would actually want to do both. I would actually want to allow some of the money to be put into creating campaign materials and so on and so forth. But also, in the end, you need some kind of sanction to stop people gaming the system.
I'm just remembering, at the time it was leading up to designation, and we thought it was sheer tactics on part of the No campaign. Because of the Welsh experience, there was a lot of rumour going about and gaming about whether they would register or wouldn't register. And as William said, there's a huge risk. You have to commit millions of pounds to free post and stuff because of the timescale of the referendum. So we could have spent millions of pounds, had loads of leaflets that we then had to pulp because we wouldn't have been allowed to spend that money on the referendum campaign if the No campaign hadn't registered. So I think to remove that, I would agree that if one campaign doesn't register, it should have no impact upon another campaign. I don't think we're in danger of that happening here, but what it would do is remove the kind of the rumour generation and the kind of gaming. But I do agree with William about I know there's no public grants proposed here, but the incentive would add to that. Obviously, if there's an incentive public grant which could be spent on an actual campaigning and not just on administration.
I think...
would you like Stuart Maxwell come back in first?
And you've heard what the two other witnesses here have said, and it seems clear from their evidence and from what I've read, and I'm sure others, that it was entirely tactical about what happened in Wales. And the ability of one side or the other, I mean, I think it's completely unrealistic in the Scottish situation, but the ability to, surely, Mr. Norton, you can accept the ability of one side or the other to block effectively the other side from campaigning in such a referendum is frankly ridiculous and cannot be allowed to happen, cannot be allowed to be used as a tactic by one side or the other.
Well, you're in a situation, I think, of trying to... all choices are bad from the situation where one side doesn't apply. Why do you have a designated organisation? It's so that you can have access to a free post mailing and television broadcasts, and I suppose actually sort of access to public rooms. But that's a sort of quasi-public duty. And I don't think I think that personally, I think you're setting a bad precedent if you can have an entitlement on one side and not the other. Just to pick up on the point about...
sorry, can I just interrupt you for a second? Clearly, the entitlement is to both sides, but one just decides not to take up that entitlement. That's quite different from what you've just said.
Well, I think you've got a genuine problem then with, for example, things like broadcasters. For example, they will have a duty of impartiality. Can they actually discharge that duty of impartiality if they're making broadcasts for one side only? I mean, I think it's a question, I don't know, I'll throw that over to the broadcasters. But I think you say, it's in those situations all choices are bad. But on my experience in the AV referendum, we did come, it was quite a fine judgment. I think Willie talks about there were rumours that we weren't going to designate. It was a real possibility that we wouldn't designate, and it was on the money, not the tactics. I can't comment on the Welsh campaign. As I say, effectively, I bet my house on being able to raise the donations to pay for that mail shot.
We'll move on from that, Stuart.
Okay.
Tavish?
Same question.
Or on the same question, or if you want to develop it in another area, please do.
Convener, just on the same point, presumably it's important here, Mr. North, not to conflate the practice of what happened in Wales and AV and the principle. Because if I read your 6.7, then what your contention in 6.7 is that this is a high-level concern because paragraph 5 of the current bill in front of this Parliament clearly creates the risk of an unfair referendum. But you're there describing the principle, not the practice, and what you've been dragged into is practice.
As I say, from that situation, all choices are bad.
Yeah.
What's the worst outcome? Is it that you have a referendum in which there are no designated campaigns, and let's say for the sake of argument it's the Yes campaign decides not to go in, but just for the sake of argument. So you've then got a campaign where the referendum is defined by the fact the single most practical point in that referendum will be that one side wasn't confident enough to apply for designated status. Electorally, that's got to kill them, hasn't it, surely? Now, the alternative is you go forward where you have broadcasters only pumping out broadcasts on one side, the Royal Mail only delivering leaflets for one side. All choices are bad in those circumstances. As I say, I suspect, I'd be very, very surprised if it arises in practice in this referendum, but you are setting a precedent for other referendums.
Can I move into a different area? I don't want to stop Mr. Maxwell.
Well, I think we've heard enough of that area. Anyway. Please go into.
Okay, I wonder if I could move on, Convener, to Schedule 4, Paragraph 25, Mr. Norton, in your evidence on control of ministers. Can I try and paraphrase, and please correct me if I've got it wrong in terms of my understanding of what you're arguing here. There seem to be two fundamental points you're arguing here. Firstly, that Scottish Government spend and the use of government grant-funded bodies to promote independence is one aspect, and the second is that ministers, in this case Scottish ministers, are not subject to the same rules on activity, investigations and sanctions as the campaigners within the campaigns. I wonder if you'd please talk to those two issues.
I wouldn't quite go as far as that. I'd actually take it as more historically. I've had experience now of two referendums in which the area covered by PPERA Section 125, the so-called PERDA, has been in point. And as PPERA is set, it has been totally ineffective at dealing what appears to be its purpose of controlling what ministers or what bodies that are funded by taxpayers' money can do. In your bill, you have taken a provision in PPERA and copied it over, word for word identically, therefore carrying over the weaknesses. And there's also been one particular provision has been missed. And I'm just curious as to why that's been missed. Because it will create a black hole, as you like, of an unregulated potential activities. Whether it will happen and how realistic, I don't know. But I mean, it's worth flagging up that if you have a provision in your bill that is based on something in PPERA, why is something missing from that original?
And could you describe that black hole? What exactly is the clause that has been omitted in this bill that is in the UK legislation governing referendum?
The basic provision says that within the last 28 days of a referendum, certain groups of people cannot do anything towards publicising or encouraging a vote. They are, for example, ministers, local authorities. In the original, it would include other organisations that aren't public bodies, but which are majority funded by the taxpayer. So they're regarded as being quasi-public bodies for the last 28 days. That final provision is missing in the bill. So there is a potentiality.
And I'm assuming, sorry, Tavish.
Can I just, why would you think that would be missed out?
Well, there are two possibilities. One is it's just a simple drafting mistake. They were copying it word for word, and then they just, went and had a cup of tea and just missed out. That's a possibility. The other reason is that someone's taken a decision to leave that out, and that's more your end of the business than mine.
No, we can obviously ask other witnesses in respect of that particular point. But what is the practical implication of leaving out that clause so that all these bodies that are funded by the government could spend money on promoting one course or another?
In theory, they could, yes. In theory, they could. I mean, they'd have to presumably register at some point, depending on how much they'd spent. But the point is, you have a clear policy justification for a legal provision, which is to stop certain entities or individuals from campaigning. Now, it wouldn't, for instance, stop a minister acting in a personal capacity or as a because in exactly the same way that you have rules on what you can and can't do before an election. So the same principle would be carried over. Okay. But as I say, I think it's a possibility, yes.
No, thank you for that. And on 911, you describe, your evidence describes the detailed rules which campaigners have to follow, and indeed what may happen to them if the Electoral Commission find them in breach, and then the sanctions that would then apply to them potentially in terms of the law. Those don't apply to ministers. Do you find that something that would need to be addressed?
It's a flaw that goes right back to PPERA.
Yeah.
That campaigners have quite detailed rules as to what they can and can't do. Mr. Sullivan will testify that they are extremely onerous. Yeah. But in the whole of PPERA, and again in this bill, the only one that catches the minister with his ministerial hat on is that one provision. So and it's been the weakest in PPERA as well.
So the UK legislation is equally flawed, and we're just enshrining the same flaws in this bill if we allow it to go through in this context. So what would be your recommendation there? Would you have a suggestion as to how this bill could be strengthened so as to achieve the level playing field?
I would invite Scotland to make a great blow for democracy and to redraft. That's it.
Can I finally
following a fair vote?
Can I finally deal with your bullet points in which you very helpfully suggest improvements to the bill? That's a very welcome principle in evidence to this any committee. You point out that the 28-day purdah period is too short. Could you describe how you could improve that process in terms of the period under which this campaign is operating, bearing in mind, of course, the Commonwealth Games and quite a lot of other things, including celebrations about battles that took time a long time ago, will also be taking place this summer, all involving government ministers.
Surely they would not use these as excuses for pushing the line. I'm horrified at that suggestion. It's been 28 days going back to the year 2000. The Electoral Commission has been making learned reports since about 2004 saying 28 days is too short. I've been putting in evidence to committees like yourself saying 28 days is too short. The Electoral Commission thinks it should actually start from the beginning of the referendum period, which I think would be the 30th of May or whatever that date is in your bill. I would actually limit it from the date on which designation occurs or doesn't occur, because a designation is effectively the date at which publicly recognised campaigners come into being, and at that point you put the drawbridge down and you say, right, public authorities, public ministers, people that take public money, that's when you stop.
Thank you.
And it wouldn't stop people doing anything in a private capacity.
I'm going to try and draw on the other two in the same question. When you're raising that, though, can I ask, on top of Tavish's area of questions, obviously all of that applies to Scottish ministers in terms of the way they operate, Scottish quasi-autonomous bodies. Should the same rules apply to the UK government ministers? And the trouble is for us, how do we make that happen in terms of this legislation will be our problem.
Well, in my view, is a resounding yes to that. I don't know how you make it happen, but absolutely.
Anyway, can I ask both Willie and Richard just to respond to some of the areas that Tavish was
I think in these things there's a kind of difficult balance to strike, because on the one hand you don't want state money being used to push a particular viewpoint, but on the other hand, and I think if you look at where we're trying to create democracies around the world, the first thing that you want to do is build a civil society, so that the civil society has to be allowed to take part in the political process. That's, most people would agree that's a fundamental of a functioning democracy. So where do you get that balance right? I'm not criticising the No campaign for the camp. They ran a very effective campaign within within the situations and incentivised by the way things were. But the No Campaign wrote a letter to any charity organisation that said they looked like they were supporting Yes to tell them that they were breaking the law. Now, whether they were breaking the law or whether they weren't breaking the law, the fact that they were scared of breaking the law means that civil society keeps out of politics. And I think, you know, trying to find a way to balance that misuse of state funds with including and encouraging civil society to take part in our political debate, I think is a difficult one to manage.
Richard?
Just responding directly to Tavish Scott's point, I mean, PERD is a very difficult issue because it makes government difficult, and therefore I understand that this is a concern. And other people have much more experience of this than I. I would only make the point to reiterate the point that it must surely apply at the UK level as well as the Scottish level. Neither government are neutral players in this particular fight, are they?
Okay, I think it's Annabel Ewing.
Thank you, Convener. On the issue, I'll just get the right piece of paper. I mean, just one last point on the PERDA and the 28-day period. I mean, of course, that, at least reading the policy memorandum of the Scottish Government further to the bill, paragraph 103, they do point out that this follows PEPERA in terms of both UK elections and referendums, and that the Government has followed PEPERA in that respect, and that the 28-day period was endorsed by the Edinburgh Agreement. But perhaps moving on, Convener, to, again, Mr Norton's paper, one of his issues was to do with grants, and indeed that has since been referred to by the other two gentlemen this morning. And I just wonder if they could perhaps state their position on that and explain if they are in favour of a state subvention by the taxpayer, why they think the taxpayer should be asked to put forward their money to a particular viewpoint. I would have thought that, particularly from the Taxpayer Alliance's point of view, I think Mr Norton's colleague has links with that organisation, and that would be a rather strange position to have at this particular moment. Thank you, Convener.
Yes. How much are you spending on the referendum?
Excuse me?
How much is being spent on the referendum?
I think I've been spending money all my life to get to this stage, Mr Norton. But the question rather was, why should the taxpayer be asked to provide a subsidy to a particular point of view? Why should the taxpayer be asked to do that? That was really my question to you. If you want to answer it. If you don't want to answer it, then please just
I'm proud. If you're spending, I think, is it 12 million? How much? It's that sort of a figure, isn't it? I believe. Yes, I've had a quick look through the financial memorandum. I'm suggesting £150,000 to each side. So you can have, you can spend 12 million on having an ill-informed referendum, or you can spend 12.3 on having a first-class, world-class referendum. I mean, I don't know. It's your call. It's your call.
Surely some of that £13 million is actually money that will be spent by the Electoral Commission on behalf of the state to actually put out the information.
Ah, will it?
Well, so that's certainly the intent, as far as I understand it. But
we can get
I did interrupt. Apologies. I should let Willie and Richard also respond.
Yeah, I mean, I understand why it's difficult to give public money to things like this at this point, but I think there's a couple of good reasons for it, and perhaps they don't need the money in this particular case. But I think there's an issue of precedence as well. If you have a reasonably low spending limit with a public grant in it, then it means that the money to be raised to run a level playing field campaign between those two things is not that large. That means it gives a huge advantage, as I said before, to a no change position that can raise money from the vested interests of the status quo. So that's one reason for that. That's a good reason for it. I think the point that I've made at the end of my paper is that perhaps then, instead of giving public money to the campaigns, which you might think sheds light on the issue, but some might argue that it just makes the issue more difficult to understand and complicates the issue. Then perhaps you would consider giving public money to a kind of citizens' engagement, awareness raising process.
Just very briefly in response to Annabelle's point. Of course, it's difficult to justify spending public money, in particular because some of the stuff will be very contentious and therefore will offend many of the people who contributed their money to, paying for this literature. But certainly the experience in Wales was that the money which was available, I understand it was a different system, but there was money available to pay for stuff which you didn't need to pay for. So you can borrow an office, you can get hold of a computer. What you need is the leaflet to put in the envelope. And that's not, or you need to pay for filming the broadcast. That was all stuff they could not spend money on, and therefore it just made it. In terms of the campaigners, the money was there. The money which was available was pointless, in a sense, and that was the issue. And in my own view is, for what it's worth, is that to echo, I think, in some sense, what Willie was saying is that when you're spending a lot of money, public money, on a referendum. The referendum in Wales cost 5 million or so in the end. And when, there were no lead designations, there was, it was just, you're spending a lot of money on a process, but not actually delivering information. And the Electoral Commission did circulate information, but it was so bland. It was so bland that it was very, very difficult for anybody to come to a judgment on the basis of the information which the Electoral Commission circulated.
Okay. Is there any other, you want to follow up, Annabelle? No?
Well, I was just, Mr Norton's point about the money provided to the Electoral Commission, that's in terms of the Electoral Commission's duties, which are quite clearly set forth, and it's not the same issue as we've just been discussing, and Professor Jones set out very clearly in his contribution there about money then beyond that to particular sides, if you like, in the argument, and that's a slightly different issue, I would have thought, Convener. Thank you.
James.
I've got a specific point to Professor Jones. You said in your initial statement that in terms of the Welsh experience you were very critical of the Electoral Commission and you don't think that the lessons had been learned from that. In terms of the referendum we face in Scotland, what lessons do you think can be learned from the performance of the Electoral Commission? What did they have to take on board in order to get it right in Scotland?
Okay, two slightly different points. One is their own report, their own reflection on the experience, which is available and which I regarded as purely an exercise in self-justification. Interestingly, there's a plaintive note in there that they'd contacted people on both sides of the campaign and nobody on the yes side had responded. But of course, 8 weeks after the referendum, we had an election in Wales. So all the people involved in the yes side were off fighting an election. These were political professionals. And therefore, there was none of that experience was reflected in their own report. And frankly, I'm not sure that they were particularly upset not to have had that response. Because, and this is my second point, when I interviewed people involved in both campaigns, there was a lot of critical noise about the Electoral Commission, about, in particular, how incredibly cautious and often opaque their responses to queries would be. There's some nodding around me here. Now, I'm not in a position to know whether that was true or not. I am not, as I said initially, an expert on electoral procedure, but there were lots of critical comments coming back to me without me actually canvassing opinions on the Electoral Commission specifically. And there's nothing in their own reports which would suggest that there was anything, their role was anything other than, jolly good. So, I can't give you specific, I'm sorry, but I can't give you specifics. All I can tell you was there was a general disquiet amongst the people that I spoke to, none of which is reflected in the Electoral Commission's own report.
Okay, Linda?
Yes, also about the Electoral Commission. The Law Society of Scotland said, I'm paraphrasing now, I may have the phrase wrong, but said, I'd always found the Electoral Commission here in Scotland to act with, I think it was absolute integrity was the words that were used. I'm therefore a wee bit concerned, Mr Norton, at your high-level concern, bullet point 1, which, you know, basically is saying that you don't trust the Electoral Commission about neutrality. And I wonder if you could expand on, why you don't trust the Electoral Commission.
You've given them a question that says, should Scotland be an independent country? You've given them the duty to increase understanding of what that question means. On the experience of having dealt with the way the Electoral Commission has prepared brochures in the North East referendum in 2004 and the AV referendum in 2011, and I'm sure Willie Sullivan will back up some comments, I don't see how they can discharge that duty with that question. In 2004, they put out a very bland document. They were dealing with two different referendums. One was on should there be a regional assembly in the northeast of England, and also in certain other parts there was going to be a reorganisation of county councils. Their document basically said, if you want to know more about the first question, contact the yes and no campaigns. Here are their telephone numbers. The first we knew about this was when people started telephoning us. It would have been nice to know that 2 million of those documents were going out beforehand. They knocked out my telephone. The actual number they gave was my private line. So it knocked me out for 2 days. It knocked out the Yes campaign's telephone for 2 days. And I think the Yes campaign actually got another phone line put in. But in the AV referendum, they had a simple mechanic. So effectively then, when you gave them something that was a very normative question, they ducked it. In the AV referendum, you'd think that actually it's actually quite a simple mechanical explanation as to how the votes work. And they did little diagrams with votes, piles of votes moving around. I had criticisms about that document. I suspect Willie Sullivan had different criticisms about that document. And that's just a simple description of how two voting systems work. I will be staggered at the Electoral Commission are able to produce anything like a document on understanding that question that doesn't in some way lean to one side or the other, and then everyone starts reaching for their lawyers. I think if you want that question and you want that duty for the Electoral Commission, you're going to have you're creating a massive headache for them. You are going to get a very bland document, or which just basically says telephone the two campaigns. The Electoral Commission is very good on some things. It's got better over the years. It's basically very good on things like procedure. You need to sign this form and get it into this person by this date. Anything like policy or anything with a normative element, they'll get back to you.
In this circumstance, are you suggesting we should just remove that power for the Electoral Commission to be able to do that?
I've set out what equivalent referendums that equivalent duty was, and it was narrower. I think you probably don't need to worry about what you do if the two designated campaigns, you can't designate on both sides, but I'd go for a narrower duty. I think that's specific. If you are the Electoral Commission, how do you get people to understand independence in a way which doesn't lean one way or the other? Now, you could do it if the question was, say, for example, should Scotland leave the United Kingdom or something like that. That's a factual thing. You can just simply say, you start off inside the United Kingdom, you end off outside it, and we won't know all the terms and there'll be a negotiation. I mean, it'll be difficult enough as it is. But it's, how do you understand that question, should, an independent country? I mean, I think it's going to be very difficult to do that without leaning on the other.
In relation to the question,
but it's not a question. It's not a question of you, madam. It's a question of the Electoral Commission.
It's been tested. We've had that discussion about the question.
Yeah. I mean, obviously, the objective is to try and inform the voters as much as possible on which to make a decision. But I think, it's an assumption that there's some sort of objective truth here when there isn't. You're giving the Electoral Commission an impossible job, really, to try and put that case. And both sides in the AV referendum thought it was biased towards one way or another. So that's what's going to happen. I mean, so I think I understand the Electoral Commission aren't going to do that this time anyway. But just to make sure, I think you're asking too much of them to ask them to do it. But as I've suggested in my paper, there are other ways. Well academic research tested around the world, ways of getting local communities to deliberate and think about issues without leading them in one direction or another, with ethically trained facilitation. And I think we would, at least consider that as a way of having a real democratic innovation in this country.
I was going to make sure Richard wanted to say in this area either before we move back to Linda.
Sorry, I didn't.
Just wondered if you wanted to comment on that particular area before I go back to
No,
Linda.
I think I made
No,
my
I
views known.
just want to say, Convener, and I think that's interesting, what we've heard from everyone about that, and we will be taking further evidence. But I think it's also worth being on record that there was I think a unanimous view across the Parliament that the Electoral Commission should fulfil that function when it came. Yeah.
Well, perhaps I could be helpful, but I mean, I think
the
section of state for...
Let's not get into an argument across here. We're supposed to be asking the witnesses questions. So, any other questions of the witnesses?
Yes.
Rob?
Yes. It'd be very interesting to hear from Richard Wynne-Jones about some of his remarks regarding the coverage of the Welsh referendum. He said there were Welsh-specific issues in the media that required to be looked at. Could you expand on that, please?
Okay, well, I'm happy to at great length, but I'm not sure you'll. I mean, for example, one of the issues was, two issues. The Welsh language dimension, in particular. They struggled to find anybody who could articulate the no case in Welsh. And there was a point where the broadcasters were seriously worried about how they could then cover it at all, which would be rather strange to have a referendum on Wales without being able to cover it in the Welsh language. And in the event, and this is where, the media found themselves, the BBC in particular found themselves, I think, at least hovering over lines they shouldn't be crossing. It was the media themselves who put two campaigners in touch with the No campaign, who then became their Welsh language spokesmen. There was also, the No campaign was so weak in terms of its on-the-ground, just lack of support, that I certainly spoke to reporters who said that they would have to make multiple calls to the No side to ensure that there was something happening they could film, so that they could then show what the Yes side was doing. So, I don't think these are in any way relevant to your own referendum. I certainly hope not. So there were these kind of Welsh-specific elements which I think maybe of interest, but probably not particularly relevant to you.
But we have the situation where we've got the BBC in Scotland and the BBC in London, and the way in which they may well operate. And I don't suppose that there was very much coverage at all from BBC in London on the Welsh referendum, but there might well be.
There was, to be fair, there was some. They felt the need to cover it and found it very difficult to do so, because if the issues of the choice between Part 3 of the Government of Wales Act 2006 and Part 4 was arcane for people in Wales, then covering it on the so-called national media was even more difficult.
Thank you, but Convener, just a question of awareness raising and the process issues relating to the Welsh referendum. You mentioned already the Welsh language element in that. I presume that the approach in Wales was to make sure that materials were available in English and Welsh, but possibly in other languages as well, with regard to the whole process from awareness to the polling place.
Certainly, it wouldn't happen in Wales these days without being in both Welsh and English.
Okay, thank you.
Although they did try and do the police commissioner one, but that's another.
Are there any other questions?
Any
other questions around the table? Okay, well, thank you very much, gentlemen, for coming and giving us evidence today. Sorry, William, I've just finished the evidence-taking session. So.
Languages, that's all.
Well, if you want to submit something later, please feel free to do so. Having concluded, I better conclude. Thank you very much, though. I'm very grateful for you coming and giving us evidence this morning. It was very helpful, and I therefore, before I close the meeting, can I also go on to say the next meeting is scheduled for Thursday the 16th, when the committee will take evidence from the Electoral Management Board, Professors Tom Mullen and Neil Walker. I think that's done. Thank you very much.